Welcome, everybody, to our webinar this morning. As Taylor already said, this is co-sponsored by the American Society of International Law, Liber Society, and the DC Bar International Law Community. And we're going to talk, as we did at the end of October, about basic principles of international humanitarian law in the context of the Israel-Gaza conflict. We are very lucky to have six, and this is being recorded. If you have questions at any point, please throw them into the question Q&A function. You can find that tab at the bottom of your Zoom screen, and I will be monitoring that as the discussion goes along. We're very lucky to have six experts with us today. We have Dr. Lauren Voss, who is a professor of law at George Washington University, former DoD senior advisor in civilian harm mitigation, and with the U.S. Air Force Reserves. We also have Dr. Ido Rosenzweig, who is Director of Research at Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa in Israel. He's also co-founder and chairperson of the Association for the Promotion of International Humanitarian Law. Sherry Cribbs, who is the chair of the Liber Society, American Society of International Law, and a professor of law at Deacon's University, also currently visiting at Stanford University in the United States. Christian Jorgensen, who is a staff attorney, very experienced in international humanitarian law with the American Red Cross. Omar Shakir, who is the Israel and Palestine Director of Human Rights Watch, and Omar Dajani, who is co-director of the Global Center for Business and Development, University of the Pacific. I've adumbrated everybody's biographies in the interest of time. We're going to begin with opening remarks from Dr. Voss.
Thanks. It's great to be here. First, a disclaimer that I'm speaking in my personal capacity and not representing the U.S. Air Force or the Department of Defense. So I want to make three opening comments that I hope frame the discussion. The first is, when we're talking about IHL, it's incredibly fact intensive. So what you are frequently seeing on the TV and news articles doesn't have all the facts that is needed to make a definitive IHL judgment call, right? So if we talk about something like, for example, the airstrikes on an IDP camp in Gaza, right? You're looking at proportionality, you're looking at the anticipated military harm, and you need to understand why the IDF knew at that time, what intelligence they had when they were making those decisions. You're looking at the expected incidental harm, and it's the same. What did they know was going on there? So did they know about the amount of people in the area? Did they know about the civilian structures? Did they know that the tunnels would collapse? Should they have known the tunnels were going to collapse? And all of that goes into the IHL analysis that goes behind this. The second thing I'd say is that IHL is fairly permissive. It's general rules applicable across vastly different scenarios in warfare. So it's meant to set those minimal standards. So that brings me to the third point, is that what we're talking about today is IHL. And so that's what you can legally do. But that's not the same as analyzing what you should do. And the United States, NATO, and then last year in November, 83 countries signed a political declaration on explosive weapons in populated areas. There's this huge movement to recognize there's more that can be done in warfare to protect civilians. There's different phrases used: protection of civilians, civilian harm mitigation, some use human security. But there's this push to say there's a legal analysis, and then there's more that can be done on top of that. And that's why these decisions that are made are not just legal. That's why it's not the attorneys always making the decisions, it's the commanders, right? The commanders make these decisions because they should be taking all of these other things into consideration when making those decisions. Back to you, Marianne.
Thanks very much. I have been teaching international law since 2003, and as a professor of international law, find that I am very often evangelizing about it, about its potential for transformation, to make the world better, to ensure that conflict is less destructive than it might be. I confess, though, that as this conflict has unfolded, it has challenged my faith in the institution and the enterprise. The United Nations Security Council, in its resolution on the Gaza Strip last month, made adherence to international humanitarian law its very first demand. Just today, in front of the International Court of Justice, the representatives of the government of Israel said that the reference point for analysis of whether its conduct in the Gaza Strip is legal should not be the Genocide Convention, but instead international humanitarian law. The implication of that, and the fact that the United States has acknowledged that it undertakes, that it sees so far no evidence of unlawfulness in Israel's actions, something that American officials have gestured at, if not said explicitly, leaves, to my mind, a really important question before us, which is if what we see on the ground in the Gaza Strip is international humanitarian law working, then what good is it? To what extent is it accomplishing the ends that were defined for it? To my mind, it's clear that this is not international humanitarian law working. And so I think that one agenda item that will be important for us today and important in the months ahead is for us to confront squarely the reasons why it's not working in this context. And to be sure, those reasons relate to some extent to power and the ways in which power inhibits accountability mechanisms from working in this context. But I'm also reminded of an intervention that Marta Koskaniemi made at a conference at the Hebrew University and Tel Aviv University on the occasion of the 40th anniversary of Israel's occupation of the West Bank and Gaza Strip, and in a subsequent law review article in the Israel Law Review, in which he asked whether the technical turn that international humanitarian law has taken, the focus on precisely the kinds of facts that Lauren has called our attention to, has caused us to lose sight of and maybe undermined its ability to achieve the mission for which it was designed. The technical analysis distracts us at times and defers a broader political analysis that should be, to my mind, a part of the enterprise that we're undertaking. And so with that, I want to say that I look forward to discussing many of the technical questions that are on our agenda, but also hope that we can think about why this approach is not serving Palestinians or the international community well. I think you may be muted, Marianne. I'm sorry.
Thank you very much, Omar, for pointing that out to me. Dr. Rosenzweig.
Hi. Thank you again for having this great event, Marianne. I want to thank Shiri and the Liber Society for holding this event. It's an amazing event. I think the previous time was great, and hopefully we're looking towards a great discussion. This time, in a way, these couple of last days have been for all the wrong reason. Don't misunderstand me when I'm going to say that about the celebration of international law in this region, because suddenly people are interested in international lawyers. We are being invited to all of the media, and we have been interviewed and everything. So people actually listen to us. The general public actually has some interest in us. At the same time, I do think that we are in a very on the edge or in the middle of a very unfortunate development of international law. Now, there is no doubt that what's going on in the Gaza Strip is horrible and unfortunate, and the vast majority of the people in Gaza are stuck between a rock and a hard place, so to speak. Hamas has created an impossible reality in the Gaza Strip where the entire civilian infrastructure is either surrounded by or embedded within military objectives. And at the same time, civilians don't really have anywhere to go to be actual safe, to be in a safe place, to have safety. And the outcome is that many of them died. Too many of them have died. And those who have survived or are surviving at the moment are suffering from diseases and dire need for food. And at the same time, Israel cannot let things go back to how they were prior to October 7th or even to stop them as they are right now, because Israel has an obligation towards its citizens, towards its residents, to maintain peace and security, to ensure the human rights, to respect, protect, and ensure the human rights of them. And Israel, as a sovereign state, has a right, as a legal right, and an obligation to fight Hamas for the goal of bringing Hamas down and to release the hostages that are being held in Gaza for almost 100 days now. And we can and hopefully we will talk about all the sexual offenses, that all the horrible things that are also being done to the hostages on a daily basis, as far as we know. And when we talk about international humanitarian law, we know that no matter, even if we accept the fact that Israel has a right to defend, Israel has a legal obligation even to defend itself or its territory and citizens and civilians. This by no means means that there are no limits to the means and methods that are allowed to be used. And the use of force by both sides to the conflict or all sides to the conflict must be conducted in accordance to international humanitarian law, IHL. But we are at the same time within an asymmetrical warfare where Hamas is not only using indiscriminate attacks against civilians, but also uses civilians as human shields. And by civilians, I mean the local people of the Gaza Strip, but also the hostages are being used as human shields. And these are clear violations of international humanitarian law. And the reality is that we lead nothing. We cannot resolve the situation without harming the civilian population in Gaza. And we cannot postpone the resolvement of the conflict either. So we need to find a way within international humanitarian law, within the general framework of the region, to reach solutions. Now, there are some calls for ceasefire, an immediate ceasefire, humanitarian ceasefire, permanent ceasefire, or whatever, and hopefully we're gonna unfold that point as well. But a ceasefire cannot take place unilaterally. There has to be at least two sides to a ceasefire, because if Israel would stop fighting right now, there are no guarantees that this will lead to any cease of hostilities from the side of Hamas. And actually, experience shows us that Hamas is capable of holding hostages basically indefinitely, because we've had people being there for 5 years. Gilad Shalit was held there for 5 years, and we have two civilians that have still being kept in the Gaza Strip, one for 9 years, Avera Mengistu, and one for 8 years, more than 8 years, Hisham Said. And despite the fact that ceasefires took place, they weren't released. So why did I say that these days mark an unfortunate event? And this is with this short comment, I will conclude those opening remarks, because we are right now witnessing from the first row how international law mechanisms are being manipulated and misused. Mechanisms that were established with the purpose, as Omar just said, with promoting humanity, promoting human rights, preventing war crimes, preventing crimes against humanity, and of course, the biggest elephant in the room right now, genocide. I honestly believe if anyone who respects international law, on the one hand, doubts that Israel has a right to defend itself against Hamas. But the question is how much and how in general it does so. So when Israel is being blamed for genocide, for fulfilling or trying to adhere to international humanitarian law, we are in a very risky place where we look at the facts on the ground and not on what were the operations and what Israel tried to do, as was mentioned by Professor Voss and by Omar, then we need to look at what Israel did and not what actually happened on the ground, because we are talking about international humanitarian law. When the notion of genocide is being forced into the situation, we are at the heart of the problem of misuse and manipulation of the judiciary system of international law, of the entire international law system, which aims to reduce harm, and actually we're at the risk of losing those safeguards that it's supposed to be providing for us. And just goes to the same where discussions over limits are required. There's no doubt about that. But if we base our assumptions on partial information, on biased information or unbased information, and then report and conclude and make a positive conclusion out of it that genocide has been taking place or a certain war crime, this or that, actually took place, we are skipping few important steps that must be taken into account. And this is a very, very risky place for international law, for international humanitarian law. And I'm really concerned about where international law is going. And I know that some of the things I've said clearly would be disagreed by the members of this panel. And if I can assure you that if we keep the same disagreement that we had in the last panel, doing it politely and respectfully, and we disagree on a lot of things, but it was a very polite and respectful discussion. We will have a very interesting discussion here as well, and actually looking forward to that discussion as well. Thank you.
Thank you very much, Ido. And for those who may not have followed the pleadings in the International Court of Justice, it's been alluded to twice. So I'm just going to briefly say on December 29th, the government of South Africa filed a case with the International Court of Justice charging Israel with violation of the Genocide Convention. That's been alluded to twice, and I think that Sherry will talk about that a little more. Christian.
Thank you, Marianne, and thank you to the rest of the panelists and everything you've shared so far. I've had to shift some of my statements that I wanted to make so I don't double dip in what each of you have said. So I've been taking some notes. But I guess what I really wanted to highlight is that, based on what I've heard so far, is that the principles of IHL are, I think we'll all agree, it's a crucial tool. It's a crucial move by the international community to protect civilian lives in conflict, also not just civilian lives, but combatant lives as well in certain cases. But it's also clear, I think, to everyone from what I've heard, that its effectiveness in each specific conflict is, in my opinion, case dependent. And this highlights the inherently complex nature of IHL's application, underscoring that its success in mitigating harm and preserving safety, it can vary. So one key aspect I do want to go back to what someone spoke about earlier is we still have to consider, when we talk about these principles, the importance of a fact-dependent analysis, because every conflict zone presents unique facts. Even if there's slight mirror situations, it's always fact-dependent on the given situation that you're looking at. And it requires a very meticulous examination so you come to the correct conclusion. And it's not always about, in my opinion, legal accuracy. It's about avoiding exacerbating an already delicate situation, because I think when we reach positive conclusions without looking at all the facts, there's an opportunity for there to be misinterpretation of the law, or a misunderstanding of the situation on the ground. And that could actually cause situations on the ground, or responses on the ground, that intensify the conflict, continuously harm innocent lives, or undermine peace efforts. So I think always acknowledging the facts on a case-by-case basis, and making sure we get all the facts before we reach conclusions. And this goes for all aspects of any conflict, any side to a conflict. I think it's incredibly important, not just for making legal determinations, but also having a healthy dialogue surrounding the conflict as well. And then I also wanted to highlight that I think it's important that panels like this exist, because they offer a platform for professional analysis and open dialogue that I think demonstrate healthy dialogue, which I would like to see more when it comes to discussing this conflict and so many other conflicts. These types of conversations, in my opinion, are vital, because I think it's important for people to hear different perspectives, challenge preconceptions to ideas, and collaborate to seek solutions that uphold the integrity of IHL, but also the world as a whole, and it respects the individuals being placed in those conflict zones as well, when we were able to have those healthy dialogues. And I hope this panel will be one of those situations, because we're bringing together diverse expertise and viewpoints, and I think that hopefully will ensure a more holistic understanding of the conflict, which I think is essential for effective and humane responses, and also legal discussion. So I'll leave it at that for right now.
Thank you very much, Christian. Omar Shakir.
Thank you. And as the one of the practitioners in this conversation, I just want to sort of start, before I get into the law, by underscoring the severity and the gravity of the abuses and violations of international human rights and humanitarian law that we're seeing on the ground. Human Rights Watch released yesterday our world report, and we found that this 2023 was the worst year in terms of killings, human rights repression in the modern history of Israel-Palestine. And I can get into what our basis was for that determination, but I think we have to ground our conversation in the legal principles with the really catastrophic reality that we're facing, not only in Gaza, but obviously also what took place inside Israel, what's happening in the West Bank. And we'll try to bring some of that into the conversation. While the abuses are unprecedented in scale, many of these abuses have been taking place for years and decades. Unlawful attacks, the kinds of repression, collective punishment, etc. And we're here precisely because of decades-long impunity for those unlawful attacks. And the reason why, again, I make this point is because, to me, what we're seeing in Israel-Palestine is a flagrant disregard for the most fundamental principles of international humanitarian law. We felt that when we spoke the last time in October, but I think we now have 3 months, 100 days almost, of evidence to back that up. When we spoke last time, we highlighted some of the abuses that lead us to that determination: the deliberate killing of civilians on October 7th, the taking of hostages on October 7th. We also spoke about collective punishment, the willful obstruction of humanitarian aid. All those phenomena are still, in essence, happening. 136 hostages being held. You still have, Israel is still not allowing it, turned off electricity and water. They've obstructed the entry of all but a trickle of humanitarian aid. It's not reaching large parts of Gaza. Human Rights Watch, and we'll get into this in the discussion, has documented starvation of civilians as a weapon of war, which is a war crime. We also see, more than 3 months in, that 1.9 million, 85% of Gaza's population, remains displaced, and there is a risk of forced displacement, which is a war crime. Again, we can get into the law and the facts in the discussion, but I want to flag that. We also have, as Ido noted, unlawful strikes, which we've documented since. And again, I agree with Lauren. It's a very fact-specific determination. When you get into discrimination, proportionality, and when you look at the use of explosive weapons, and sometimes it's more straightforward, but we have that dynamic as well taking place, and the consequences are dire. I mean, 9 out of 10 people in Gaza are starving, according to the World Food Program. Over 500,000 people facing catastrophic hunger situation. And why this matters for our discussion, again, we're not focused on the facts, we're focused on the law, but why it matters is because these are a disregard of basic principles of law, many of the same ones that have been invoked in many other contexts. And if we allow this to continue, the consequences for protection of civilians will be felt far beyond Israel and Palestine. I think really we're testing these principles on the ground. I think, again, a couple of people referred, and I know Sherry will say more about the ICJ proceedings, but here we have a quite simple example. It happened with Myanmar and Gambia. It's happened in other cases where you have a chance for the world court to scrutinize the conduct of a party, right? And every one of us should be saying that we should abide by the court's decision, and that an inquiry, given the gravity and severity of abuses, is warranted. It's straightforward. It's basic and similar with the International Criminal Court, which, again, a lot has transpired since we last spoke, but their formal probe is vital. The ICJ's probe is vital, and the need for consistency, double standards when it comes to applying international humanitarian law undermines protections for all of us. We're being tested as international lawyers, as a community that cares about the protection of the international legal order that grew out of the ashes of World War II. It is being literally demolished in Gaza. And I think our duty, and I hope we can all agree on that, is to protect that system, because as ugly as war gets, without that system of laws, it could be even uglier. Look forward to discussing further.
Thank you very much, Omar. Sherry.
Thank you, everyone, for participating today. And so I just want to perhaps re-echo something that Omar Dajani opened with today about feeling so devastated by both the reality and also the power, or the potential even, of international humanitarian law to make some positive impact or influence parties' conduct in this and other conflicts as well. And I think about this because I was really excited about the opportunity for us about a previous discussion at the end of October. Like everyone else, I thought we had a spectrum of views that we managed to discuss in a friendly and respectful way, which was helpful in a way that's in a world that's becoming more and more polarized as the days go by. But as Omar Shakir just said, I think we are almost 100 days after October 7, and things have been deteriorating rapidly, not only, in the, kind of on the ground, right, with what's happening on the ground, but also with the legal discussion becoming more intensely polarized in a way that perhaps really kind of triggers the question of what is IHL good for today? And as Omar Shakir also just mentioned, we still have 136 Israeli hostages still being held by Hamas, with a baby, a young child, young women being abused on a daily basis, and no real hope for their release. And we have a dire situation in the Gaza Strip with, the facts were just elaborated on yesterday, at the ICJ by the South African team. And just listening to the factual description is really, horrifying. And again, with no clear way in which IHL can make an intervention. And perhaps the genocide case currently being discussed is a good example of some of the futility of IHL mechanisms, and perhaps because exactly because of its kind of heightened or polarized terminology without concrete tools to, impact the behavior of parties to the conflict. And in this regard, I think, I was thinking this morning, listening to the arguments at the court, about this gap between, or the gap and at the same time, the connections between fact-finding, serious fact-finding, and legal terminology. Because it seems like we can't even agree on some of the most basic facts of what's happening, on the scale of the violence, of the devastation that it causes to real people on the ground right now. And then we quickly shift to the legal meaning of these facts, right? So what does it mean with regard to the Genocide Convention in this case? And this brings, I think, discussions and debates that we don't necessarily have to even engage with in order to kind of trigger IHL's kind of minimal, as Lauren said, protections that may be useful. But it's really impossible to identify, I think, at this point, even a single rule of IHL that doesn't trigger this intense discussion about how it should be applied to this conflict. And perhaps, going back to, Karl von Clausewitz, known saying that politics is merely the continuation of war by other means, it seems to me that international humanitarian law has been the continuation of this war by other means, and, especially within the international community, as we discuss the genocide case and other principles of IHL as well. And so I'll just to say something a little more concrete before I end my opening remarks, I'll go back to something that Ido said. And perhaps it can be, one of the bases for our discussion, because I think Ido's criticism of this case was at least in part relying upon the fact that Israel has a right to self-defense, and I think we might agree that that Israel has a right to self-defense. I definitely agree that following the attack of October 7, Israel had a right and an obligation to protect its civilians. However, I do not think that it has anything to do or to preclude, let's say, a discussion of genocide or the violation of the Genocide Convention, because genocide can occur also during an armed conflict. And this relates to, I think, something, Marianne, that you said in our kind of briefing before we started the panel about, retaliation and rules of retaliation within IHL. And I think, to me, this is not, even an open question. To me, it's quite clear that retaliation, or in this case, revenge, is not a permissible principle of IHL. So states cannot use violence, merely in retaliation or to express revenge for violence that occurred prior, right? So the principles of proportionality and necessity and distinction and precaution all, are just as valid when we think about behavior that is responding to a previous violence. I think in the Israeli, and I've been, talking with my children about the conflict, and it's always this question of who started, right? Because when you explain this to kids, but there is always something that happened before. And so I think this discussion of who started, right, or this is self-defense or this is retaliation, is particularly counterproductive in this context. So I'll just put it there as a point that, at least in my mind, the arguments for self-defense do not at all preclude the potential for the commission of genocide, if indeed there is a combination of actions and the mens rea, or the kind of mental element, or the special intent that's involved in genocide. So I'll leave it at that, and I'm happy to elaborate on the factual and the legal side of any of those. Thank you.
Thank you very much, Shiri. So everybody has raised wonderful, or not wonderful, but really interesting issues in international humanitarian law. Because three of you have mentioned specifically the case brought by South Africa, Let's begin with the charge of genocide that South Africa has leveled, which Shiri has very nicely laid out for us. What are your views of, one, the case that has been brought before the International Court of Justice charging Israel with genocide against the Palestinians, and two, the fact that South Africa is filing that case, or any other aspect of the case, for those of you who listened to the opening arguments or have read any of the pleadings?
I can start if that's okay,
Please.
because I've read the pleadings. I've watched carefully in the last couple of days all the hearings, and generally, I don't think I need to address to why South Africa other than anyone else, because it could be any state for that matter. I don't think we need to point fingers at one state or another for taking that approach. Israel's position was that there was some connection between South Africa and Hamas. I don't want to get into that. I don't think that this is very relevant to the discussion on the question of whether or not genocide is taking place. I think that the main question for the current discussion is the provisional measures. It's not about genocide at the point. It's still not on the merits of genocide, whether there is genocide or there isn't genocide. Right now, the entire discussion is about the provisional measures being that South Africa is asking. And I think that this is where the focus should be at this point, because South Africa is asking for, if I remember correctly, 3 or 4 provisional measures. One of them is that Israel will stop fighting, just cease its military operation. Another one is allow more humanitarian aid to get in. And the third one is to stop the incitement of genocide that is taking place within Israel. Now, as was very much discussed today, it seems that the complaint against Israel and the general presentation of things that took place yesterday by the team of South Africa was very partial, and I don't want to say, well, for the some matter unbased. Now, the based stuff, the based elements of that is that people are dying in Gaza with large quantities of there's a lot of damage going on to the civilian population in Gaza. They were required to go, or they were asked, ordered, or told, whatever you want to use that frame. We'll go into the IHL part of it later on, to go from the north to the south for their what Israel considered their protection as precautionary measures. And if you put all the elements that South Africa is pointing at, you can see that if we look at them from international humanitarian law perspective, and I think this is part of what Omer Dajani has referred to, you could argue that some of them are legal, some of them might be violations of international humanitarian law. But if you compile them together, South Africa claims that this is the genocidal act. And then the other aspect of the special intent of genocidal, this part was, I think, very well described today by Israel as giving too much weight to marginal claims, horrific claims by politicians and other people from public, people who appear in the media. Some soldiers on the ground have said that as well, but that was giving way too much weight in order to base the element of intent. Now, I think that people who actually are familiar with the Israeli politics, with the Israeli culture, know exactly how to differentiate between political claims meant internally, which are aimed for internally for their own voters to gain some minimal political gain, and statements that actually can have an impact, that actually can affect the soldiers on the ground, can actually affect what is being held on the ground, what is being conducted on the ground. And if you combine them together and you ignore that differentiation, that understanding, and you go and make a cumulative amount of all those statements, a cumulative weight of all those statements, you could argue, yeah, we have that intent. But that intent is being undermined basically by every element related to international humanitarian law that is being conducted by by Israeli Defense Force, allowing humanitarian aid, not enough, but allowing humanitarian aid, telling people to go away from the strike zones before striking them, giving 2 weeks notice before actually attacking hospitals, allowing the hospitals to be evacuated. And even when the hospitals were attacked, where IDF got into the hospitals, no one got harmed from those attacks. IDF strictly separated from the people in the hospital and from Hamas objectives. So when you look at the case and you hear both sides to the story, I think in my perspective, there are no grounds for the merits of genocide. Unfortunately, the threshold of provisional measures of plausible genocide is so low that the chances that the court will decide that provisional measures should take place and give some provisional measures, and I don't want to take more time than what I've already taken, but it's a big question of what those provisional measures will be and what would Israel's response to those provisional measures will be just as well. And I will end with that.
Thank you very much, Ido. Omar.
Thank you. I want to say a couple of things, which is, I do think this is a momentous moment for international law and for protection of civilians, and it should be widely embraced. Regardless of what you think about the allegation of genocide, and I agree with Ido to break up the substantive hearing on the merits and sort of differentiate that from the provisional measures. For those who are not familiar with the ICJ, I think it's like an analogy is like an injunction. It's sort of, but just for those who are not as familiar. And we expect a ruling, again, just for facts for people who aren't as familiar, on the provisional measures within weeks based on the ICJ practice. I think it took 40 days in Myanmar and Gambia. Russia, Ukraine was 2 weeks. The court composition will change next month, which could be a trigger, but that's just facts. But 2 points on the substance. The first is in terms of, on the merits, and one is on the provisional measures. On the merits, to me, we as international lawyers should embrace this historic opportunity to unlock a process at the world's highest court to credibly examine Israel's conduct in Gaza and ensure compliance with the Genocide Convention. I want to read to you a submission that a bunch of European states, just a line from a submission that was made by Denmark, France, Germany, UK, and the Netherlands in the Myanmar-Gambia case in 2022. They said, a contracting party, this is to the Genocide Convention, should act where appropriate through recourse to multilateral mechanisms when taking action to prevent genocide, including when carrying out an assessment of whether genocide is occurring or at serious risk of occurring. So even if one doesn't believe genocide is taking place, the fact that the world's court is providing a forum, an independent body to hear facts, to make a determination, I can't understand why any international lawyer would be opposed to this, especially because it again combats this idea of international legal mechanisms being a resort for the powerful and a tool for the powerful, right? This is South Africa. I think it's significant. This is a state that shook off the shackles of apartheid. It's not by any means perfect, and its record on, international law is by no means perfect, but the fact that it is, holding the World Court to apply consistently the law that we've cited in so many other contexts, I can't understand why anybody would oppose this inquiry, regardless of where you come down on the merits. The point is, a court is going to make that determination. They take an oath, all judges, to be independent, and we should support and call on states to abide by. And I think France's ambassador to the UK, that should be a template for states who don't want to support the substantive findings. They should support the proceedings, and they should support the court. Final point on provisional measures. I understand Ido's point about a lower threshold, but the court by ICJ practice is not bound by what South Africa asked for, right? They can issue any measures. And the idea here is these are measures to protect civilians, curtail suffering, and ensure compliance with the Genocide Convention, and allow the hearing to be heard on the merits, not prejudged by facts that happen in the coming weeks or months. Again, I can't understand why, in the face of what we all agree are catastrophic conditions that Palestinians are facing, why we would not support the court doing that sort of inquiry. How many more civilians must be killed or suffered, before the world takes actions to act and to support these proceedings? To me, as lawyers, there should be no doubt, regardless of where, and we can have a debate on the merits of genocide one way or another, on any other war crime, but this hearing itself should be widely embraced. I'll stop there.
Thank you very much, Omar. Shiri.
I also want to thank Omar for his passion and always being like the optimistic lawyer. And because I don't know, maybe it rubs on me a little bit, even though I started kind of very pessimistic. So I'm just wondering, Omar, though, if you would still find this as historic moment if the court then decides not to intervene on technicalities following, let's say, Malcolm Show's argument on, some of the jurisdictional issues, or if it finds in favor of Israel, or if it just refuses to, have any sort of kind of follow-up, actions, right? So would that still mean something? But I do agree with you that it is important that the entire world seem to, or at least maybe in our community, but to us, maybe it seems like the entire world, or people everywhere at least, are listening, tuning in, and hearing some of those arguments in a forum that's not Twitter or TikTok or, not fake news, which perhaps, is not something to be disregarded at all. And so listening to you, I was just thinking, actually, finally, we have some sort of a discussion that's not fake, right? That, or at least, even if not all of, some of it is propaganda, you can say, but at least, it's a serious type of argumentation that perhaps we should, embrace in a world where we listen to less and less, read less and less, and care less and less about our sources. And the point of substance that I wanted to make related to Ido's comment on the mental element, because I fully agree that the crime of genocide has a really huge threshold, and with regard to the mental element of the special intent, and typically will not find people that kind of order genocide or that have this special intent, special genocidal intent, say out loud, kind of give kind of a very clear-cut order, let's kill them all, in the same way that Israeli politicians have been saying repeatedly in the last couple of months, and perhaps even before. And so I think if this is kind of not enough, then what type of evidence can we have that would be suffice to say that we have the special element? And I just want to go back to the terrible incident that happened. Everything that happens in Gaza is terrible, but I think the incident in which Israeli military killed 3 of the Israeli hostages when they were escaping, holding a white flag, shirtless, yelling help, and kind of calling for, speaking in Hebrew, doing whatever they could to signal that they are in fact innocent civilians, and they were still killed. And I just wonder, I just have to raise this as doesn't it tells us something about the actual orders? And we do have you know, not specifically perhaps in the last couple of weeks, but throughout the years of this conflict, we had testimonies by Israeli soldiers testifying to Breaking the Silence organization, saying that, you know, the orders have been, you know, kill whatever moves, right? And I think this, you know, we have the facts on the ground where you see people holding, you know, white flags and kind of surrendering and still being killed. And so it must, you know, signal something with regard to the orders. Now, if we did have all the orders, and that would include the informal ones, that would be, of course, an easy kind of determination. But considering that we don't have all that kind of informal order that trickles down, we have to rely on something. And I think that kind of disregarding statements by politicians, and some of them quite senior, I find this disturbing. I mean, should we think that Israeli government is completely clueless, politicized, doesn't mean what they say, but still we have, you know, massive amount, scale of devastation. And so I think this is something that must be, you know, dealt with a little more kind of seriously, rather than saying, oh, it's just kind of, you know, talking to their base, political base.
Thank you, Shiri. Omar Dajani.
Thanks very much. I'd like to echo a point that Shiri made in asking how we go about proving genocidal intent if we can't refer to the kinds of things that have been said. I think that's a really important thing to think about at this juncture. But I would really commend the South African application to folks in the audience who haven't had a chance to read it, because one of the points that is made, I think, powerfully in the application is that there is a connection between the statements that are made by political and military leaders and the kinds of chants and statements that are made by individual soldiers on the ground and to the actions of those soldiers on the ground. Now, as we've been discussing, there will be a need after at a later juncture to assess how strong the connections between leadership statements, military sensibilities, and military conduct are. But to have the opportunity to lay out all of that and to have the communications that make that possible is a rare event, and one that I think gives a lot of strength to the call for provisional measures to be taken. And I do want to just say a word about provisional measures. I think one of the arguments that Israel has made challenging the value of provisional measures at this juncture is that it would hamstring its military effort while doing nothing to constrain Hamas at this juncture. And what I would like to point out is that what the court would be doing in these circumstances is not constraining Israeli military action for all time, nor, as Omar Shaker hinted a little earlier, would the court be saying that Israel can use no measures whatsoever to advance its legitimate military objectives. But what it would be doing is calling for a significant shift in the way in which this war is operating so that we remove the threat of continuing civilian catastrophe. And when we consider that threat in light of how limited Israel's achievement of objectives so far has been, how little has been done, apparently, to secure the release of hostages, which, of course, I agree have been improperly, unlawfully held. How little has been done to disable Hamas at this juncture, Not to mention the broader consequences politically of Hamas's position, and that's a conversation for someone perhaps other than a bunch of lawyers. I think it's not difficult to see the logic and value of provisional measures at this juncture, to see this not at all as an unreasonable request, a disabling request, but a means of allowing people to catch their breath.
Thank you very much, Omar. Lauren.
Yeah, I just wanted to make a couple points. I like Shiri's mention of the hostage incident as something to look at to kind of see what's happening on the ground. I come out of it with a slightly different takeaway. I mean, what I see is a fog of war, right? Like just complete confusion on the ground about what's going on. I mean, as she said, they had no shirts on, they had a white flag. The sniper that initially shot, said that his guidance was, this is a combat area, there's no civilians. You're allowed to fire on anyone suspicious. Obviously not, that's not compliant with IHL. But it's not clear that that was the actual rules of engagement at the time. And so the IDF chief of staff has clarified that what happened was against their rules of engagement. Obviously, none of us have seen those rules of engagement. They're classified. But, the battalion commander at one point said to hold fire, and a soldier fired anyway. So it just seems like there's this level of confusion on the ground, concern, security issues. And we've seen Hamas do things like dress up as IDF soldiers, right? And put on the uniforms, yell things in Hebrew, play sounds of babies crying, right? And so there really is this confusion on the ground that makes it hard to know how much of this was intent and guidance and how much was just that kind of confusion. The IDF chief of staff did come out and, clarify that, hey, if you see someone waving a white flag, you should not shoot them. They may be hostages. And that was followed up with, well, actually, they may actually just be civilians. You need to keep that in mind. But the fact that you have to keep reminding people of that, I think should create a sense of nervousness on compliance with IHL, if that's how people are thinking on the ground because of how the conflict is going. There's also has been accusations of summarily executing Palestinians on the ground. I think, in the same city, in Gaza City, in December, around that same time frame. We haven't seen the facts coming out of that, though. But so there's different pieces that go back and forth. So to me, I read that as a lot of confusion. And until I could actually see that guidance, it's hard for me to say what was happening there. I mean, to the statements, though, that leaders are making, sure, they're not all relevant to the conduct of hostilities, but these are ministers, right? And so when ministers are coming out and saying these things, people obviously listen. And then when you don't have other senior leaders coming out and calling that into question and saying that's, that is incorrect, or we shouldn't be saying that, or it's not what we're doing. So, I think that condemnation needs to happen. Because to me, you could also then look at incitement to commit genocide as an issue here, right? And like what those people are saying in that situation, even if you don't have the actual intent and then actions to do it. So there's a question of incitement, but then I look to 400 to 600 strikes a day on certain days, right? If you just look at the numbers, and I'm an intel officer, the amount of research that has to go into that, and especially when it happens every day, as you have combat occurring, you have IDPs moving around every day. So trying to re-verify that
IDP. IDP.
Oh, yeah, internally displaced people. So civilians that have been, forced out of their homes or are looking for safety and security, moving around. The facts on the ground, like what is happening is changing every day. So trying to re-verify that that is indeed still a valid target, that your proportionality analysis is still good and there's not a camp of civilians now there. When you're doing that many targets in one day, it calls to me the question of how could you revalidate those targets in a timely fashion? How could you ensure that what you're targeting is still what you think you're targeting? That's just an enormous number. And granted, that's not what they do every day, but that's the ranges they've reached on certain days. So I think there's some questions just about what that process would be. But quite frankly, for me, I see facts going both ways. And, I haven't seen the internal documents, the internal conversations to really feel confident making a call one way or the other.
Thank you very much, Lauren. I see that both Ido and Omar would like to contribute to this fascinating and really important discussion. We have 2 questions in the queue. So I would like Ido and Omar to go ahead and make their remarks quickly, and then I'm going to try to go to the questions. Ido.
Thank you. I am gonna really try to be brief, unlike my usual nature. One comment is about the Shiri made a comment about the fact that this is in front of a court and not Twitter and not fake news and everything. But I think the fact that this is a very distinguished institution, some of the claims that were made by South Africa, which might not be well based, will resonate much stronger if they're being made through that platform. So that also should be risky. And I'm not going to go into details because we do want to move forward. On the 3 hostages, this is something that I find I'm very passionate about, both because I care about the hostages, I volunteer for the Forum of the Families of the Hostages, and I'm helping over there. But also I wrote enough about this topic that I want to address, and this is the notion of perfidy and treachery. When we talk about the textbook of perfidy and treachery, we say that the reasons that we have those protections is because if we use treachery and we use perfidious measures and treacherous ways of operation, we undermine the protection of the civilians out of them. Because if we know that the enemy is using and disguising civilians as targets, or being disguised or using dolls and using civilians, or disguise itself as civilians, or injured civilians, or even hostages, in order to attack the adversary, the immediate outcome of that is that more civilians will be harmed, because the other side will be more suspicious about what he sees in front of it. So therefore, when we know that, as Lauren mentioned, that Hamas is actually using those tactics, we need to look very carefully about the situation of the 3 hostages. We need to know what happened the day before and 2 days before, when they actually saw people under similar circumstances that were actually Hamas fighters disguising themselves as civilians. And so we need to be more careful with how much weight and how we analyze that scenario, even though I agree that attacking a person holding a white flag, or a person that perceives to be a civilian, an uninvolved civilian, I should mention, should be the last thing we even think about doing. We need to take every measures we can in order to ensure that we are targeting a real target.
Thank you, Ido. Omar.
Very quick comment on the 3 hostages. The first point, which is often ignored, is the hostages should have never been there. Hostage taking is a war crime. That's been left out of the conversation. But I do want to say that this was not a one-of-a-kind event. Human Rights Watch in 2009 put out a report called White Flag Deaths, where we documented 7 instances in which 11 Palestinian civilians were gunned down carrying white flags. They included 5 women, 4 children. It's a 70-page report. Type in White Flag Deaths, HRW, you can find it. There have also been reports and videos, we have not verified them yet, of a woman in this conflict being shot waving a white flag. So we need to understand again that this took place in a context in which nobody was held to account for those actions. We followed it this is during the 2008 hostilities. So I think there's a need to understand that in the wider context, civilians may never be attacked. Yes, perfidy, you're right, is unlawful, Ido, but there clearly wasn't the case here. And I just think sentence I'll say is that we need to be very careful as a fact finder. My job as a researcher to bandy about allegations for which there is just no fact to substantiate them.
Thank you, Omar. Christian, I see your hand is up. You have 1.5 minutes.
Yeah, I just wanted
60
to say.
seconds.
Yeah, I just wanted to say quickly, and it's not excusing or defending anything. I just think it's always important that people realize that IHL allows for good faith mistakes to happen. It allows for mistakes to happen. IHL recognizes that in the confusion and complexity of armed conflict, genuine mistakes can happen. such as misidentifying a civilian object as a military target or a civilian for a combatant. Those things tragically happen. It's part of the reason that the world got together and tried to limit the negative consequences of warfare, because there are harsh realities of warfare. Even the Pictet commentary acknowledges that on multiple fronts, that there are harsh realities to warfare, and this is the best that we can do. But at the same point, it's not excusing anything, but mistakes are allowed to happen. If a party to a conflict in good faith mistakenly targets what it believes to be a legitimate military objective, it doesn't necessarily constitute a violation of IHL. If there's a repeated practice that has been mentioned, the violation isn't so much targeting civilians. It'd be that type of mission approach to that situation is a violation of IHL. But at the same point, like, we have to acknowledge that mistakes can happen, and I just think that needs to be said.
Thank you, Christian. That's very helpful. Okay, we have 2 questions in the queue, and I'm going to exercise moderator's license and edit them. So the first question, which is 2-part, addresses the question which was brought up in introductory remarks of the use of starvation as a method of war. That is a violation of international humanitarian law. Is that correct? Omar.
Yeah, I'll take this since we published a report on this. Yes, starvation of civilians as a method of war is a war crime under international law, and our report on this specifies sort of the basis for that. And just very quickly, we reached that conclusion based on a few trends that we've been documenting over numerous months. And I should say, starvation of civilians as a method of war, it's in the Rome Statute. Also that intentionally starving civilians by depriving them of objects indispensable to their survival, including willfully impeding relief supplies, is a war crime. And then we also talk about collective punishment, but our finding there was based on obstruction of entry of aid, the sealing of crossings, not allowing electricity and water in there, so the aid and the goods. Third, it was destruction of objects indispensable for survival, so things like water and sanitation facilities, bakeries, granaries. Fourth, we looked at satellite imagery regarding apparent deliberate razing of agricultural land needed to produce food. And finally, statements of Israeli officials setting out, this is not small officials, Prime Minister, Defense Minister, National Security Minister, folks in Kogat, basically saying in plain terms that they are, making these moves to cut entry of food and aid otherwise until it accomplishes their objectives, whether it's release of hostages or destruction of Hamas.
Thank you very much, Omar. The other question, which is very broad, I'm going to, again, exercise moderator's license. If you had to choose one tenet of international humanitarian law that would be most important in this conflict, which would it be? Nice, easy question, huh? Shiri.
Not easy, but I'll take it. So I think, at least in my mind, in this kind of area of kind of legal polarization and politicization of international humanitarian law, I would like to see more serious collaboration around fact-finding. And because we all agree on the importance of fact for legal determinations in this conflict, I would also like to kind of have a more serious thinking about the fog of war metaphor that was mentioned here several times. I agree that the fog of war can sometimes be a challenge while in real time, and Clausewitz again said when coining this fog of war metaphor, basically was talking about the courage to act under conditions of uncertainty, right? But while kind of coining this term, he actually meant that you have the obligation to do, the best you can. And clearly this means sometimes you'll make a mistake. But this doesn't mean that the fog of war lasts forever. At some point after the fact, we can collect more fact. The fog of war should disperse, and we should know more at least. And I think that in recent conflicts, not just in the Israeli-Gaza one, we see that the fog of war is this sort of forever fog that always remains, we never go back to, and can always explain and justify everything as a mistake that was conducted under conditions of uncertainty without, even having the full integrity of, uncovering some of those facts that can be uncovered.
Thank you, Shiri. Omar.
I completely agree with what Shiri said. I would add one thing to the person who asked the question. I think we can't forget that the core proposition that is being offered by international humanitarian law is distinction, that there is a distinction between civilian objects and military objectives. And civilian objects are not an appropriate target for military action. Now, it's equally important to understand that this core proposition is undergirded by two obligations. One of those obligations is to take all feasible precautions to verify that targets of attack are not civilians or civilian objects. And I think that's very pertinent to the conversation that we were just having about the episode with the hostages and the from what one reads, many analogous episodes in which Palestinians have found themselves. But in addition to that, international humanitarian law says that where there is doubt, persons and objects should be presumed to be civilian. And so these three things, distinction, precautions, presumption, operate together to ensure that we don't simply end up saying fog of war every time we find ourselves trying to analyze a particular factual situation and to determine what a commander should do.
Thank you, Omar. Ido.
Thank you. I think one element that is being somehow overlooked here is that international humanitarian law is meant to create a balance between military necessity and humanity. You need to balance between both of them. And the notion of distinction, the notion of precautions, the notion of proportionality are all meant to help us to conduct that balance. But if we've put the focus too much on the humanitarian part of IHL, we basically try to say, well, wars should not be fought. Fine, wars should not be fought. If we can have world peace, I promise you, I'll be the first one to support that, with that notion that I will probably lose my main occupation. But other than that, wars are there and states have a right to protect themselves. And if states under certain circumstances are allowed to use force, and if we only focus on the humanitarian aspect of IHL, we kind of create a limitation of the fact that states are allowed to use force. States are allowed to use force within the limitations of international humanitarian law. And I think that the answers given by Omar Shakir and Omar Dajani and Shiri tends to ignore the fact that in an armed conflict, your main goal is to defeat the enemy, while using legal means and methods and use the relevant restrictions for the use of force.
Thank you very much, Ido. We have 5 questions remaining in the queue, and I want to personally apologize to those questioners. I'm going to circulate those questions to the panelists, but I wanted to leave each person time to make some concluding remarks and thank everybody. I think the number of questions indicates how meaningful this discussion and important this discussion has been. Lauren, would you like to conclude?
Yeah, thanks. I would say that, the fog of war is not an excuse, right? I was using it in the context of if we're looking at specific intent, right? And so if there's, other situations going on, there's been instances of perfidy in the past. But I would, we can always get better. Every military can get better. And so you point to training, better processes, better info and intelligence. And I would continually advocate that learning for every military that's involved in military operations right now. I would just make sure that people think, as we talk about the specific IHL principles, we're not, missing the forest for the trees, right? Like, so there is an estimated 18,000, Palestinians who have been killed, 50,000 injured, right? And then, we have 1,400 Israelis were killed, 240 hostages, 7,000 injured, right? Like, so we have massive amounts of people, innocent people that have been harmed here. And I just want to take that into consideration when we sometimes get into the weeds of IHL, that you want to think about that bigger picture. And I just say, if this conflict bothers you, but look at the other ones, right? Look at Syria, look at Yemen, look at Myanmar. And this is not unique to cause that much human suffering from conflict. And so I'm just a big advocate of saying we can get better. And so if you are, paying attention to this, pay attention to what else is going on. And then I'd also just say, as an American, you can look even at U.S. coalition actions in Mosul, Raqqa, after our operations, 60 to 80% of Raqqa was uninhabitable. Right? Like when you do this kinds of encirclement of large populated areas, there was just massive civilian harm that comes on the back end of that. So I would just, advocate one, make sure you're looking at the bigger picture, and two, look at the other conflicts around the world where this issue is repeatedly coming up again and again. Thanks.
Thank you very much, Lauren. Omar Dajani.
Thanks very much. I'd like to make 3 points if I could. The first is something that we haven't had much occasion to talk about this time around, but that I think needs to be a frame of reference. And that is that the Gaza Strip is occupied territory. And has been recognized to be occupied territory for the last 50 years, even though the extent to which it is occupied has been contested since Israel's redeployment out of the Gaza Strip in 2005. The fact of occupation is something that is relevant to a lot of the questions that we're grappling with. As Von Lowe argued at the International Court of Justice yesterday, it's relevant to the question of whether Israel has a right to self-defense in this context, how we should think about what Israel's rights are under the laws of war when dealing with a population that is entitled to protection under the law of occupation, and that has very few options available to it with regard to where to go and how to deal with the consequences of conflict. And so I think that context is very crucial and shouldn't be overlooked. A second point that I think that we need to grapple with is recognizing that in this context, not every military objective that is articulated is one that we should that we should accept as valid. I want to give just one example. There's been a lot of discussion about destruction of Hamas's tunnels, and indeed Ehud Barak, the former Prime Minister of Israel, acknowledged that some of the tunnels were built by Israel at an earlier juncture. I can understand the desire of Israel to undertake to eliminate tunnels that have undermined its control of territory that it's occupied over these last years, and to eliminate tunnels that have been a means of getting what's necessary to build weaponry into the Gaza Strip. But I also want us to bear in mind, there's nothing illegal about building tunnels. There's nothing illegal about building roads. And as we are thinking about what is an appropriate reaction on Israel's part, when we see Israeli officials say, well, if in order to destroy the tunnels, we have to destroy all of the cities in the Gaza Strip, and you do hear statements of this kind being made, we've got to sort of be prepared to say, well, wait a minute. In what way are tunnels different than roads? To what extent is it a proportionate response to rocket fire that could be intercepted for the tunnel complex to be destroyed? Precisely what is the appropriate balance that we should aim to achieve as far as proportionality is concerned? And then I'll end by just noting something that we discussed a little bit during our last panel, but which, in light of everything that has happened, seems important to reiterate, which is that for 20 years or more, Israel has very explicitly made disproportionate response a centerpiece of its deterrence strategy. And when we are looking at intent in these contexts, I think we can't fail to remember that point and factor it into our analysis of what's lawful. Thanks very much.
Thank you, Omar. Ido.
Thank you. I have a few final comments. I'm going to try to be super brief on them. But I want to start with Omar Dajani's second comment about the tunnels and military objectives in general, that we don't have to attack them. And I agree that we don't really have to attack every military objective that we see just by the fact that we have defined it as military objective. But the question of not whether or not it's worth the destruction worth attacking, it's a military commander's perspective. If there is nature, location, purpose of use, we IHL lawyers know to quote that automatically. If it is a military objective, it is allowed to attack. Now, if the damage is going to be not disproportionate, then under IHL, this is it. This is where we stop. And comparing the question of whether or not attacking the tunnels would stop launching rockets, I think it might even be a confusing in bello and ad bellum questions, but I don't want to go more than that. I go backwards, the question of occupation, which was Dajani's first comment. I really thought that we can bypass our disagreement on that issue in this panel, but I have to go back to say that, again, I disagree with the notion that the Gaza was under occupation on October 7th, for sure. And I think that the amount of force Israel is using trying to get control over areas in the Gaza Strip just shows how lack of control it had over that situation. But I do think, and this is definitely a topic for a thorough discussion, if Israel has reoccupied the Gaza Strip or parts of it, and what are Israel's obligations as a result of that. And this is a topic that I think is overlooked by the fact that we're saying that Gaza has been occupied for the entire time. We lose a very important discussion about what are Israel's obligations right now as it's reoccupying the Gaza Strip for the amount and the level that it has occupied it. And my last two short comments are when the entire discussion that we have keeps bringing me back to that notion that I've been hearing from my long time old PhD supervisors while I was writing my PhD on the right to life of combatants. Are we talking about lex lata or lex ferenda? Are we talking about the law as it is or how we want it to be? And I think that a lot of what we hear in this discussion is the way we want to envision international humanitarian law and not the way international humanitarian law is right now. And I do believe that we need to aspire towards the lex ferenda. We need to inspire towards the change of international humanitarian law, but I don't think that we can apply our desires to the actual law and try to apply it and try to analyze everything and basically change us alone what international humanitarian law is and what it says. And lastly, real nice comment, I think, is that if we look about the list of topics that we've had, I think we didn't even scratch the surface for that discussion, which might bring a question of shouldn't we do another one later on. So thank you very much for this discussion.
You took the words right out of my mouth, Ido. Christian.
Yeah, I'll just be quick because we're running out of time, but I think it's important to recognize that because there's a lot of question on the effectiveness of IHL. I don't think it can ever be quantified. I'd also say what I believe I said in the last panel, that we'll also never know things that didn't took place because IHL exists. And so I think it's important to always keep that in mind. I think IHL has areas that we should be improved and added upon, but I'll also say that it's never going to be exactly prevent everything from happening, because, you know, even Pictet in his commentary in the Geneva Conventions, remarked that there's a crucial balance between the acknowledgement of the reality of war and the aspiration to mitigate as much human suffering as possible. Like, you have to still acknowledge this balancing act, as Ido has discussed in his past comments. But I'll also say that in essence, I think IHL is the best tool we have to navigate these complex and often brutal landscapes of conflict. And I think that it's truly important for us to make sure that when we discuss it, we're discussing it accurately, and not that I would think anyone in this panel was doing that, but not in a way that just supports what I want the conclusion to be. And sometimes I hear that when it comes to all sorts of conflicts, I would also encourage people, you know, we talk a lot about this conflict, but there's other conflicts going on in the world that the Red Cross specifically is working in. And I think it's always important to highlight that this isn't the only conflict going on, and we need to talk about IHL issues and all various conflicts happening as well. And I guess the last thing, on a positive note, part of the reason I think IHL is the best tool that we have is because I think it embodies the collective human endeavor to infuse war with a sense of humanity, whether that sounds paradoxical or not. But I think it is a tool that we've put together as members of the global community, and we should continue to add on to it and strengthen it and shine its light whenever we have the possibility to do so.
Thank you, Christian. Omar Shakir.
Yeah, 3 final points. I know I said this last time, but since for those who weren't listening, I mean, Gaza is Israel's bound by international humanitarian law. It's the occupying power even before October 7th, and controlled the airspace, access to territorial waters, the population registry that issues ID cards, movement, sans the exit to Gaza. It controls the access to resources, the infrastructure Gaza relies upon. That's why the ICRC, the UN, and most countries in the world consider it occupied. I don't think it's a particularly controversial point. Second is regarding the statements by Israeli officials. I want to be clear again. This is not a statement this is not a discussion of facts of law, but the statements. And I encourage you to read Human Rights Watch's starvation report. We quote the defense minister, the national security minister, the energy minister, the deputy head of the civil administration. We quote the coordinator for government activities in the occupied territories. We quote the prime minister, senior advisor to the prime minister. These are not peripheral statements. They're being made at the highest levels of the Israeli government. The final point I want to make is about the fog of war, because I was glad Lauren said her comment at the end, because I want to be clear. We're talking about Israel-Palestine. We're talking about a 56-year-long occupation. We're talking about thousands of airstrikes. We're talking about strikes that hit schools and hospitals. We're talking about entire neighborhoods reduced to rubble. We've documented unlawful airstrikes in these hostilities, use of white phosphorus. We've been documenting this in every round as Human Rights Watch for decades. Unlawful strikes, indiscriminate strikes, disproportionate strikes, unlawful use of force in the West Bank. We're talking about the majority of the population displaced, the majority of homes destroyed or damaged. This is not fog of war. This is very clear, flagrant disregard for international law. And I'll end where I started. The consequences of us not taking action to address them will affect the protection of civilians everywhere in the world, not just in Israel-Palestine.
Thank you, Omar Shiri.
Thank you. So I'll also take this kind of bigger picture approach, and thanks, Christian, for reminding us that it can always get worse. I don't know. I don't find much comfort in the thought that, you know, perhaps some, you know, things that IHL prevents some horrors, because I think the horrors that we are witnessing in this conflict are already way too much to witness. And so I don't take much comfort in the thought that things can get, you know, even worse than that. And so I think perhaps for me, the one point that we haven't touched, and I think is crucially important, is what happens next, right? So we have at the moment huge devastation within the Gaza Strip, with senior Israeli officials fantasizing about retaking this area and resettling their, you know, Israeli Jewish communities in the Gaza Strip. And so with that and fantasizing, of course, about really, kind of reducing the amount of, Palestinians residents in this area. And so what happens next, right? And we talked about other conflicts, and clearly the world is messed up, not only in this region. But what happens next? So we have right now huge amounts of civilians suffering from starvation and suffering from lack of clean water and disease and no functioning hospitals and so far. Where can they go, right? Where can they get relief? Can they now, be accepted as refugees elsewhere? And obviously, refugee status is supposed to be temporary, right? Can they come back to their houses? When can they get back? Who will rebuild? And so looking at all those questions about rebuilding and coming back and, restoring life in Gaza, while, senior Israeli officials are fantasizing about, reducing the number of Palestinians living there permanently and kind of fantasizing about resettling Jewish communities in the West Bank, I think to me, that's the number one question that the international community should engage with. So how do we assure that, and we can put aside, right, all the questions about Israel's right to self-defense, and we can put aside all the question about what Israel can lawfully do to protect its civilians and its citizens, which I agree that, Israeli citizens should also enjoy a level of security in their own homes that they currently do not have. And so if we put all that question aside about how to fight this war, can we start thinking about the next day and who would ensure the rebuilding of Gaza and the safety of Gazans in the Gaza Strip alongside the safety of Israelis? So last moment, just because I know we're out of time, I'm just saying apologies again to everyone who didn't get their questions answered, but I'm very happy to continue this engagement over email, Zoom meetings, and continue the conversation online, offline. And obviously, perhaps really like Ido mentioned, there is a room for another session. I really enjoyed our discussion today, and I really respect everyone's views. Thank you.
I want to thank all six of the experts for an excellent discussion and with plenty of civil disagreement of a very critical subject from which I personally learned a lot. My apologies again to the audience members who didn't get their questions answered. Thank you to the audience for their participation, and we will let you know when our next discussion is scheduled for. Thank you all.
Thank you very much.
Thank you, Marianne.